Good afternoon, counsel. Proceed.
Who are 14 injured workers. I'd like to reserve 5 minutes for rebuttal, if I may. This case comes before this court on a certification from the 9th Circuit Court of Appeals. This case originated in King County Superior Court, where workers filed a claim that they were deliberately injured by their employer, amongst other claims. That was removed to federal court and dismissed on summary judgment. An appeal was taken to the 9th Circuit, and the 9th Circuit, after reviewing the issue, felt that guidance from this court was needed. We are not asking for this court to change the law. We are simply asking that this court permit these individuals to have their day in court. They were injured in 1987. They have yet to have this issue heard on its merits. The law provides conspiracy by technology. The law specifically provides that if there's a deliberate intention to produce injury, then a civil cause of action exists. If facts sufficient to establish that point can be inferred from the evidence on summary judgment, then these people are entitled to their day in court. There has been in the briefing some suggestion that there are public policy issues involved. The public policy issue that I believe is clearly stated by the legislature is this, stated in RCW 51.04.010, which is the welfare of the state depends upon its industries and even more upon the welfare of its wage worker. So when we're interpreting this exclusion to the bar created by the Workers' Compensation Act, I believe it's appropriate to suggest that we're looking to protect workers. That's indeed the purpose of the act. Determination of deliberate intent to produce injury has been held repeatedly. Indeed, in every case that's dealt with this, to be a question for the jury. And questions such as intent has also repeatedly been held to be appropriate for a jury determination and inappropriate for summary judgment. And on summary judgment, all these facts must be construed in favor of my clients. We believe the evidence is clear. Let's go and take a look at that evidence, because I think that's where the case must rise and fall. First of all, this case, in terms of toxic chemical exposures within the confines of the Washington statute regarding deliberate intention, is a case of first impression. But there's nothing special about toxic chemical exposures. It's just one more instrumentality in which workers can be injured. You can be injured by a forklift, by a hammer, or by toxic chemicals. That isn't dispositive at all. There have been Oregon cases based on an identical statute, and this court has on several occasions held the Oregon statute to be identical. In the Biggs case, it specifically found it to be identical to our statute, and more recently in the Winteroth case, we found that the Washington and Oregon statutes are virtually identical. If the injury results to a worker from the deliberate intention of his or her employer to produce such injury, as Oregon states, if injury or death results to a workman from the deliberate intention of his employer to produce such injury, then the worker shall have the privilege to take under this title. The workman shall have the privilege to take under this act. These are identical statutes and have been construed to be identical. The reason I bring this up is because this identical statute has been interpreted on virtually identical facts to create an exception to the Workers' Compensation statute. In the case of Lusk, the court said a jury could find that the defendant knew the plaintiff was suffering injury from the paint, that was involving paint fumes, knew that he would continue to do so as long as he worked without a supplied air respirator, and after deliberation, consciously decided not to provide such a respirator. It could therefore find that defendant's acts were deliberate. Now, our case is much more, I think, persuasive and clear than this. We don't have to get into that murky gray area where we're talking about possible risks. We're talking about actual knowledge of harm happening to workers. These workers being sent into a toxic environment where, by internal memorandums from the Boeing company, and this is one such which was submitted to the Ninth Circuit and to the court below, we see here specifically a request, a facilities request, that air ventilation be put into place because during material research and development layout of phenol and prepreg, employees complain of dizziness, dryness in the nose and throat, burning eyes, and upset stomach. We anticipate this problem to increase as temperatures rise and production increases. This was anticipated. There's nothing accidental about this. And if I might say, as a general principle, the workers' compensation statute correctly shields employers from liability for negligence because accidents will happen in the modern workplace that are unavoidable. We're not talking about accidents here. We're saying you know it's going to happen.
Mr. Gordon?
Yes, sir.
May I read to you from the Boeing brief and ask you to comment on this and tell me why you think this is incorrect? This is a proposition that the employer has submitted. Evidence that an employer is deliberately engaged in conduct that results in occupational injuries or disease within its workforce is not evidence of a specific intent to injure members of that workforce for purposes of RCW 5124.020, so long as that conduct was reasonably calculated to advance an essential business purpose.
Bringing that up. That is seeking to change the law of this state. That proposition is seeking to shield what we would regard in most circumstances as criminal conduct. The Ford Pinto case would have been shielded by that, because simply you're saying it's a justifiable business purpose to make a profit. We needed to use this material. Workers must be sacrificed. Now, if I may say that this case goes beyond that, but the emphasis I want to make is that is a proposition. That is where Boeing is seeking to get the law to go. That is not what the law is in this state.
Well, they're saying that is what the law is.
Well, I differ with that because I believe that it's quite clear that that would justify an employer saying, we need to use this flammability-resistant material. We're going to use it. We know workers are going to be injured. We choose to make that as an economic choice. And that would make it okay to do that. And I don't believe that the welfare of the wage worker in this state is advanced by a policy that lets businesses sacrifice its workers and conceal the evidence of that sacrifice, changing the work conditions every time a government inspector comes in, having workers with known medical restrictions have those restrictions pulled under threat of termination, force people back into the workplace, people who are already injured, so they succumb to further injury. Here is just some of the evidence. I'm not suggesting that simply exposing people to toxic chemicals creates liability. And I'm saying when you knowingly expose them, anticipate the problem to increase. You know the solution is putting in air ventilation. And then, a month later, much like the Lust case, you refuse to spend the money. And you're making a business plan which embraces the notion of inevitable worker injury. That is not what workers' compensation is intended to shield. It's not intended to shield an employer who chooses to injure his workers, or her workers, or its workers. And the fact is, what Boeing has advanced throughout this case is the notion that there must be some kind of emotional desire to harm. That someone at Boeing must say, let's get the workers. I don't believe that's necessary or possible in a corporate environment. No, I'm afraid, just as the Robert Frost poem says, some say the world will end in fire, some say in ice. And in this case, it is the cold-blooded business calculation that is the greater threat to the workers of this state than Boeing company getting together and in anger hurting its workers. That's not what we're proposing.
You think that what you're seeking the court to have indicate is the law of Washington is consistent with the Delphoni case? That's the old case, the 1922 case, where the court said, we think by the words deliberate intention to produce the injury that the lawmakers, speaking of the legislature, meant to imply that the employer must have determined to injure an employee and use some means appropriate to that end. There must be a specific intent and not merely carelessness or negligence, however gross.
I agree with that, Your Honor. I believe that existing law and law for the last 70 years, under this statute, specifically contemplates that it be difficult but not impossible to establish deliberate intent. And I believe that we mustn't go and engage in too much philosophy here. There's a difference between intending and embracing an injury and sacrificing your workers, knowing that harm is going to happen, and an accident. Every other case in this state where they've rejected that notion, for example, the Birklid case where a cable snaps, there's an accident. Something happened that was unintended. There's nothing here that was unintended. They said workers are getting sick. We anticipate they're going to get more sick. Let's have ventilation. No, let's not. They do get sick. We remove medical restrictions from people who are being injured. We conceal test results which shows guilty knowledge. All of these inferences must be taken in our favor. And to say that you cannot even infer, for purpose of summary judgment, deliberate intention from these facts is to make it impossible to ever show intention in the corporate environment. So I agree. I think deliberation means what we think it means. It means that you think about it. It means you think about it beforehand. You weigh the pluses and minuses. They decided that the quality of life of its workers and the injury of its workers was less desirable than making a profit. And they made that choice. Now it's time to take the consequences of that choice. The state of Washington didn't intend for businesses to be able to make that kind of choice, to injure workers. Now that's different again from the auger where a person, in the Nielsen case, a person slips and accidentally gets hurt. Or in the flying cutter head case of Winchlock where you have a risk. We're not talking about a risk. We're talking about intentional acts.
But counsel, if I could stop you for a second, the Lusk case talks about a conscious weighing of the consequences. Higley and I guess Alsop, the Foster case, talk about removal of safety devices, that kind of thing. That's a weighing, that's a conscious decision being made. I mean, where's the difference between Lusk and those older Washington cases then? Is it in the knowledge that Boeing specifically had that its people were being sick?
Well, I think that is in the knowledge. And let me show you some of that knowledge. Because I think that it's like being hit by a slow bullet, you know? It's like you press a button and you know people are going to be hurt, and you press the button anyway. That's called intention. They pressed the button. And dozens of workers were injured, not just my client.
But if you remove the safety device from the circular saw,
then there's a chance someone will be injured. Here we're talking about people who are injured. You know they're injured. You see them being injured, and you let it continue to happen. It's like the kid. What's it like? It's like marching worker after worker into that saw. That's what it's like.
so you're differentiating between the risk of harm and the actual knowledge of specific harm that the employer had.
I'm raising the same question that the Ninth Circuit had problems with, which is on page 7 of my reply brief to the amicus, Washington Self-Insurance Association. They said to counsel, they said, but if you know there's harm happening and you do it anyway, isn't that intention? And counsel said, well, you could make a distinction there. This is not the Higley case. This is a case where you remove, first of all, this is a summary judgment issue. Everything should, you have to go and, trust me, you have to believe what we're saying here in terms of the affidavits. We have 11 affidavits of individuals saying that they brought fans in, changed production methods, removed this material from the workplace every time government inspectors came in. This is an inference of guilty knowledge. And they continue to expose workers to these conditions. They talk a lot about air levels, even though for summary judgment they have to concede them. But let's make a few points on this score. We have a material safety data sheet. I apologize, it's difficult to read, but then it is impossible for my clients to read because one of the facts is that this was not made available to them despite request. The material safety data sheet available in 1986 says for phenolic resin mixture, there is no level established. There's no exposure level established. None. We see in 1988 experiments being done without the informed consent of the workers. One, I've gone to another individual, Lisa Kemplin, who is not the party to this case. They were exposed to levels of 0.01 parts per million, and it was followed by nausea and vomiting and being evacuated by ambulance. This kind of conduct is not negligent. This isn't an accident. This is 2 years later. see my red light is on.
Please the court. My name is John Farrelly, and I represent the Washington Self-Insurers Association, the amicus in this matter. Mr. Wilson, on behalf of the Boeing Company, has allowed me 4 minutes of his time, which I appreciate, so that I may have an opportunity to express to you some of the concerns of the employer community in the state of Washington. I will try to speak more to the policy implications of this case rather than this type of case rather than a specific case. Preliminarily, I'd like to remind the court that this case implicates the Industrial Insurance Act. Unlike any other type of civil liability situation where the Industrial Insurance Act is involved, we have a system of no-fault insurance. In exchange for the responsibility of paying industrial insurance benefits to workers and their dependents and beneficiaries, an employer gets immunity from civil liability for any injury or disease caused to a worker. The one exception to that is the deliberate intention exception of RCW 5124.020, which I suggest is a narrow exception to an otherwise broad grant of employer immunity. Now, when the appellants talk about, if you don't allow them to proceed or suggest that they should be allowed to proceed, they'll be denied a remedy. Again, I'd like to suggest that there is a remedy. It's called workers' compensation. And those benefits, again, are paid without fault on the part of the employer and without regard to fault on the part of the worker. Even if the worker is at fault, those benefits are paid.
Counsel,
But the workman's compensation system was never intended to cover intentional torts. What kind of a system would be that an employer could share his liability for an intentional tort by making other people pay for it? That was never the intention.
I'm not suggesting that an employer shouldn't have to pay for damages that are caused by the deliberate intention of the employer. I just would like to remind the court that in a normal situation, there is immunity from liability, and the deliberate intention exception is a narrow one. The other thing with respect to remedies and not financial awards, but rather the remedies that are provided by our Industrial Safety and Health Act. Under the Act, the Department of Labor and Industries can promulgate rules and regulations governing safety in the workplace, can conduct inspections, can cite employers for violation of those rules, can even obtain an order of immediate restraint prohibiting and violating an employer from continuing their operations. Now, with respect to deliberate intention, one thing I would like to point out is that I had always thought I understood what it meant, that the employer determined to injure the worker and took some means appropriate to that end. Under the theory espoused by the appellants, I'm not sure I would know that would be the case, and I'm not sure the employer community would know at what point would they be potentially exposed to liability under 5124.020. Two concerns that I think the employer community has. One is that people in the workplace get hurt. If people in the workplace did not get hurt, we would not need an industrial insurance system. Now, employers may not know who's going to get hurt or when, but it's a fact of industrial life that people will get hurt. The first point I'd like to raise is with respect to what type of conduct would expose an employer to liability. I suggest that the theory espoused by the appellants, almost any case involving a potential occupational disease claim, where the nature of the disease is that over a course of time it develops and there may be symptoms of almost any case where there's an occupational disease claim, an employer could be exposed to liability under the statute. Secondly, even if there ultimately is no damage award in these deliberate intentions lawsuits, I think the court needs to be concerned with the fact that employers will still have to defend, will still have to go to the expense and cost and legal fees to defend these cases, and maybe those types of resources are better spent on industrial insurance benefits and safety. Thank you.
I'm V. Woolston, and I represent the Boeing Company. Boeing Company, as you all know, is in the business of manufacturing and selling transport category aircraft. They carry their business out in a highly regulated environment. Unlike other manufacturers in this state, Boeing Company is required, before it can ever build or sell any of its products, to satisfy the Federal Aviation Administration that all applicable FARs are complied with. In the absence of such evidence, they can't get a type certificate, they can't build or sell their products. That regulatory environment is constantly and appropriately under change, and an important change occurred in July of 1986, when the FAA determined, in view of the tragic loss of life that would occur in some accidents that were otherwise survivable due to flames and smoke in the aircraft cabin, that it would significantly heighten the flammability requirements applicable to interior materials. And they placed a time horizon of 18 months on that announcement. The announcement was made in July of '86. The implementation was scheduled for January of 1988. In many businesses, that would be a significant advanced timeline. In the production of aircraft, it is an emergency deadline. Faced with that deadline, the company immediately went into a search to find a product that could build interior cabin materials that would meet that flammability requirement, and it did find that product. It was manufactured by Faro Corporation, and it was given the designation CPH 2284P. It was introduced into production in August of 1987, following significant pre-production testing, including air monitoring testing. Now, the implications of the air monitoring testing is a subject of dispute here. I want to be very careful in describing what the evidence is on that subject. The evidence is that the Boeing Company did do air monitoring tests before introducing this product. It did air monitoring tests after the introduction of the product when the complaints began, and it continued air monitoring tests throughout the period of time that the product was in the workplace. All of the results of those air monitoring tests on the days they were taken showed exceedingly low percentages of the applicable PPM.
Counsel, what relevance does that have? Do we not have to take the assertion of the facts by the plaintiff on their face? That is, that Boeing manipulated the testing process on the site, that workers were getting sick with a variety of symptoms, that MSDS not made available to the workers, that labels were manipulated, and so forth. Don't we have to assume, for purposes of this matter, that those assertions are correct?
I believe it has significance, but only in a limited area, Your Honor. I believe that we have conceded that we are not resting our motion for summary judgment or the court's decision below on the notion that the results obtained on the dates of testing were indicative of the existing conditions throughout the work period. They have raised substantial questions of fact as to whether the results obtained on those dates of testing are representative of the true working conditions due to their allegations of fan placement and cleanup. However, the fact remains that the tests were done, and that at no time did the tests ever generate scientific evidence that would give credence to the complaints that the plaintiffs were bringing forward about hazards associated with this material. And I believe that's significant to the extent that this court would look to a case that the plaintiffs have relied upon, such as Golden versus Crown-Zellerbach, in which the exact opposite was the case. The Ninth Circuit, following Oregon law in that case, was faced with a situation where Crown-Zellerbach, the employer, had knowingly assigned workers to work in an environment that had, and they knew it, and the evidence had shown it, 500 times the level that of PCBs that the EPA had previously determined to be safe. That presents a very different fact context from the one presented here, even if full credence is given, Your Honor, to the questions about representativeness that the plaintiffs have raised.
Counsel, that seems to me to relate only to the testing issue. I mean, what we have here is an allegation made by the plaintiffs that people were literally passing out. The air was white with dust, that this chemical was present, and people were cramping, they were nauseous, et cetera, et cetera. I mean, don't we have to take those allegations on their face for purposes of analyzing the test for deliberate intention to injure?
I believe those allegations do have to be taken and given credence, Your Honor. scientific validity of their personal conclusions as to what was causing their problems, I don't think is something that this court is required to accept. So what I would suggest to you is that the Boeing company was clearly on notice from the very early stages that these workers believed that they were being injured because of the phenolic resin material that was in the workplace, and they were put on a duty of inquiry to determine whether that was in fact the case and to take appropriate action. And that appropriate inquiry was the air monitoring evaluation, and it ultimately led, despite the fact that no scientific evidence of actual harm ever was developed, to the implementation of precisely the air ventilation requirements that Mr. Gordon has alluded to. Now, the initial decision was made that such improvements in the facility were not necessary based on the low levels that were being observed. But notwithstanding that fact, when the problems continued, the improvements were implemented that the plaintiffs have indicated were appropriate. And the only thing that we're really in question on is whether the timing was correct. Did they move quickly enough to respond to these worker complaints? There's a fundamental difference, I believe, in the approach that the two sides take to the determination of what is meant by deliberate intention. It's the Boeing company's position that the legislature's intent, and is reflected in the decisions of this court over 80 years, is that the exception is quite literally limited to circumstances where the object of the employer's conduct is the injury of the employee. It is not a byproduct of conduct that the employer is engaged in to accomplish some other purpose. And in this case, a particularly legitimate business purpose, which is manufacturing products in compliance with FARs. The plaintiffs, on the other hand, would suggest that, and I take this from their reply brief at page 14, but it continues to the earlier stages of their briefing. I quote, "From the common law of malice of forethought to common experience of any child, purposely doing that which is substantially certain to produce injury must be regarded as deliberate intention." And going back to their earliest brief in front of Judge Kuhnauer, they state, "The evidence shows directly and by reasonable inference that Boeing management, in order to continue producing airplanes, accepted worker illness as a necessary byproduct." That is a very different notion of the deliberate intention exception than what I believe this court has ever endorsed, in which it's only been found in two circumstances in the entire jurisprudence of the state. The Perry case, which involved a vicious personal assault with a water pitcher, and a forklift assault in the Mason case just a couple of years ago. In those instances, the agent of the injury was used as a weapon, not to achieve any legitimate business purpose of the employer, but specifically and solely to inflict an injury upon the person. And as I read the plaintiff's briefs in this case, I don't believe that they're suggesting that that was Boeing's intent. They're asking you as the court to expand the understanding of deliberate intention to include what, in any other context, we would be referring to as constructive intent. And that is a doctrine wherein one is deemed to have intended the natural or foreseeable consequences of his intentional acts.
So, counsel, under your formulation of deliberate intention, there would have to be the smoking gun memorandum someplace in the record saying, "We, the Boeing company, intended to injure employee X, employee Y, and employee Z in order to establish deliberate intent."
That would be one potential example, perhaps an unlikely one. The more likely circumstance would be the kind of thing that happened in Perry or in Mason, where you essentially have what I would regard in most cases as a rogue employee who's acting in a management position, who deliberately goes about bringing about the result of an employee's injury.
Then in your formulation under Golden, where the employer, I think it was Crown Zellerbach, exposed the employees down on their hands and knees to concentrations of PCB 500 times the permissible level, because there was a business purpose present, that would be permissible under Washington law in your formulation?
That's a much tougher question, Your Honor. It doesn't fit the case here, but let me answer it directly. I do not believe that as this court has previously articulated the standard that the Crown Zellerbach case would come out as it did in the Ninth Circuit applying Oregon law. I don't think the court needs to make that decision to reach a conclusion here because A, we don't have the facts as you've just described them, And B, there's nothing essential about accomplishing the work that they sought to accomplish in the way they were doing it there. They had available to them toxic cleanup experts and others who could have done at a greater cost that which they had sought to do apparently through casual labor. Here, there's very little more essential to the Boeing company's continued existence in operation than its ability to produce airplanes that will comply with applicable FARs. And there's no evidence that there was any product available in the state of the art that would allow that to occur other than the phenolic period product in question here. Let me point out another distinction before I leave that point.
Counsel, but before you do, I'm still trying to understand the formulation Boeing's advanced. Would the question of reasonable business practices under those circumstances be a jury question? Or would it be something that the judge would decide as a matter of law on summary judgment?
Your Honor, I view in the first instance the obligation of the judge to make that determination because his jurisdiction depends upon it. I think there's something very distinct about the workers' compensation bar in that it is not a limitation of remedies provision. The legislature did not say that individual workers will have the right to have a civil cause of action for workplace injuries, but their remedy will be limited to instances where their injury has been inflicted intentionally. It does not do that. It tells the civil courts up front that they do not have jurisdiction to even entertain such claims in the absence of evidence that the injury in question was inflicted deliberately. And if I could then use that question to follow into the point that Mr. Boeing has advanced, which is that notice to the company of complaints is tantamount or equivalent to knowledge that injury has in fact occurred, because I don't believe that follows. The Boeing company did not know and does not know today whether any of these individuals truly suffered any injuries associated with their exposure to or work with phenolic resin. The fact that the question when posed in the workers' compensation setting has resulted in very mixed results is testimony to that, and that evidence is set forth, reference to that is in the record in Judy Shirky's affidavit at the clerk's papers, number 81, Exhibit B. Plaintiffs in many instances did not prevail in the workers' compensation setting, not because workers' compensation doesn't provide a remedy for this kind of injury, but because they were unable to establish any causal link between their complaints and the exposures they received. So even if in the fullness of time with medical testimony on all sides, the Industrial Insurance Board could not make a determination that injury was in fact occurring, then certainly it would be inappropriate to assume that the mere lodging of a complaint vested Boeing with knowledge that these workers were being injured as a result of their exposure.
If Boeing did have knowledge that workers were being injured by virtue of toxic materials and deliberately made a decision not to do anything about it, would that be a deliberate intent that we could find?
I believe you could posit a hypothetical situation where you did have that knowledge, which I don't think is our case, in which a readily available solution could have been implemented and was consciously not implemented. And I think my view, Your Honor, is that a court could come to the conclusion that a reasonably functioning jury could conclude that that is evidence that a jury could find deliberate intent. I don't believe that's our case, and I don't believe it's a question that the court has to reach to answer the summary judgment that's been asked to review.
What about this report of Mr. Johnson, who was a Boeing supervisor, saying that during obnoxious odors were present, employees complained of dizziness, dryness in the nose and throat, burning eyes, and upset stomach. We anticipate this problem to increase as temperatures rise and production increases. And Boeing, at least according to the plaintiff's evidence, ignored this and went ahead anyway. What about that?
What they in fact did, Your Honor, was they pursued the air monitoring evaluation, and they determined that at least on the days that the air monitoring was performed, that there was, and it's evident right here in the exhibit Mr. Gordon brought, where the phenol PPTEL, 5 parts per million, so they were registering 2 orders of magnitude away from what the scientific consensus consensus has indicated a threat. So they were confronted with information that the employees were complaining. And certainly the odors is a subjective thing. Many workers don't like various odors, and you and I might not like them either. But faced with evidence that they were at such a low level that they couldn't be harmful.
Well, but then he goes on to say that there's proof that, as predicted, these complaints have risen to an alarming level. Even Mr. Johnson's eyes were affected, the person that had made the original complaint. I mean, it seems to me you're asking us to weigh this evidence, whereas the question from the Ninth Circuit is whether the evidence produced by the plaintiffs in their response to the motion could, under Washington law, justify a jury finding. We're supposed to be looking at the plaintiff's evidence, aren't we?
Correct, but only for the purposes of determining whether the specific intent requirement has been satisfied. Not whether they were on notice, or whether they could have done better, or they could have been more careful. I must advise the court that my red light is on, and I will just conclude my argument.
Thank you, counsel.
For the purposes of summary judgment, Boeing conceded below that their levels were inaccurate. And here, all we hear are levels, and yet that whole argument of levels is really a red herring, because we know from the material safety data sheet back in September of '86, before these materials were introduced, we know that phenolic resin mixture, they were not established. Instead, they're going to the next line and they're saying that the phenolphthalein is below those levels. But they've said nothing about how. It's just interesting. It's interesting because the way Boeing looks at the charge is a lot different than the way the plaintiffs look at it. We don't look at measured concentration levels and say, gee, we have to look how low the levels are. We look at this column and say, gee, these workers are throwing up. And if you can expose them to 0.01 parts per million and have people getting sick, does that mean they're not getting sick? They don't have a right to get sick at these levels? Or does it mean that this toxic chemical makes people sick? And we've seen it happen over and over again. This is in 1988. They're still undecided. Even today, before this court, they say these people believe they're injured. So how responsive was Boeing under those circumstances? There are ways that Boeing could have shown it didn't mean to cause harm. It could have approved the adequate ventilation. It could have encouraged workers to report symptoms. It could have conducted testing which was not rigged. It could have left the labels on the material so workers could take precautions for themselves. It could have, when workers had medical restrictions, could have observed those restrictions. Instead, it's just the opposite. It refused the ventilation. It discouraged workers from reporting symptoms. It threatened them with termination when they showed up with restrictions on their medical condition from their doctors. Every one of these facts creates an inference, along with the guilty knowledge of affecting the test results. Now, I think that these workers not only believed they were injured, but I think we must assume for summary judgment purposes, they were injured. And, you know, I kept on thinking about Oliver Wendell Holmes' remark in the common law where he says even a dog knows the difference between being tripped over and being kicked. These workers were kicked. There's nothing accidental about knowing that and anticipating workers are going to be exposed to novel chemical combinations, that they're getting sick. We need ventilation, which is the simple kind of cure that would have helped certainly remedy this. And instead, we see none of this behavior on the part of a caring employer. We simply see a more probable scenario, which is this. We need to use a flame-resistant material. Workers aren't machines. You can't get them to do it if they think they're being injured. So how do you do it? How do you get the product out? Well, first of all, you rip off the labels so the workers don't know what they're dealing with. And you threaten them with termination. You keep the machine running. I don't think that is an acceptable choice, but that is certainly as probable, as reasonable an inference from this evidence as the notion that, gee, they just thought they were being hurt when they were all throwing up and being taken out on ambulances. Now, I think that it's more probable. We don't have to prove this case, but I think it's more probable that these workers were really injured, that they were exposed to novel chemicals for which there were no established levels, and that Boeing chose, because it needed to produce the product, it chose to look the other way, knowing that as part of its business plan, it was sacrificing workers to achieve its business goal, not their business goal, its business goal. And making money, if making money is an excuse, if that means that the welfare of the wage worker in this state is going to be secondary to the profit motive of the industry, sacrifice them, you can conceal from them, you can hide from the government. The inspectors who come by a few times, you can change the workplace conditions. All of these facts must be taken to be true. And on the outrage, the tort of outrage, I simply say this. If these facts are true, on what right? On what right does Boeing stand here today and say we can engage in this kind of conduct and be shielded from liability? That is not what the workers' compensation statute was intended. It was intended to protect the workers, not intended to subject them to a conscious plan to sacrifice them for business goals. And by the way, when the FAA said you don't need to use this material anymore, Boeing pulled it out. Well, so much for business necessity. Businesses when the problem, then only then did they decide, well, maybe now we can put some ventilation in, and we're working as fast as we can. Every time you press this button, 30% of the workers are in the bathroom throwing up. We're talking about disenfranchised women, we're talking about minorities, we're talking about all the people who need your protection. Every time you press this button, they're getting sick. But every time you press this button, you get an airplane. And they've been pressing it for 2 years.
Thank you, counsel.
Thank you very much.
We'll proceed to the next case.